Hello and welcome back to our YouTube channel. Well, it is lecture number 28 of Indian Polity and the date is 15th July 2025. And currently we are discussing Indian Judiciary, and it would be the second uh, lecture on Indian Judiciary, and hopefully it would be the last lecture. So before we start our discussion, I would like to give the brief introduction about this initiative which we started from 2nd June 2025, so that if you are new to our channel, you will get more connected with us. Actually we started this initiative by the name Target IAS 2026. Under this initiative, every day we are uploading two videos on our YouTube channel. One is in the morning session where we discuss the current affairs of yours, and second is in the evening session where we discuss the static syllabus. And here we had started with Indian Polity, and it is the 28th lecture of Indian Polity, and after three lectures we are going to wind up Indian Polity. After that we will take up the governance part of your syllabus. So here we had promised you that by the month of January 2026 we are going to complete your full syllabus, and in this we will discuss every topic which is relevant for your prelims as well as mains. So you don't have to worry about these subjects, but here there is an exception. We are not going to take the classes of the optional subjects. And one more thing which I often say, that as we are preparing these lectures, as we are delivering these lectures, at the same time we are preparing your notes which would be available once we will complete the syllabus. After 3 days I guess notes would be available. In these notes they are very much different from your conventional books, because after while we are writing these notes, so we take one thing into the consideration, that after every topic which we discuss there should be a relevant possible prelims as well as mains question, so that once you are reading those articles, when you are reading those topics and you look at the questions asked from those articles, it remains in your mind that how this article, how this topic is important for your preparation, and in a way you prepare well for the exam. And also there may be chances are that these questions may coincide in the exam. That is something different topic. So in this way we prepare your notes. If you want to get the service of these notes, you just have to mail us once they would be available, and then you will have to pay 200 rupees per subject. It is up to you. If you want to get them, that's fine, up to you. And if you like this initiative, this much, the free lectures which we deliver here, they are totally free. If you want to be the part of it, if you like them, please do subscribe the channel, do share it with your friends so that they may also get benefited from this initiative, and also please do write in the comments what else should we bring for you guys. Now without any delay, let's start our discussion on Indian Judiciary. So it would be the second class of Indian Judiciary, and from today, in today's class we will discuss various other concepts. Let's try to recap what we discussed so far in Indian Judiciary. We started with what is the role of judiciary. We discussed that. In the what is the role of judiciary, after that we discussed what is the hierarchy with respect to the offices of the judiciary. We saw at the top it is Supreme Court, then we saw there is something called High Court, then we saw there is something called District Court, and then we saw there are tribunals are there which we had not discussed yet, and even District Court we had not discussed yet. Then we saw there is something called as Gram Nyayalikas, so which was introduced in 2009 actually. So these are the offices of the court, office of the judiciary, which which give the judgment. And then we saw that what is the role of judiciary, what is it, why it is important. After that we saw what is the first, we took up the Supreme Court. We saw what is the composition of the Supreme Court. What does the Article 124 Clause 1 say? What is the composition of Supreme Court? Then we saw that how are appointments done. With respect to the appointments, we saw 4 judges case, including the NJAC, which is the 4th judge's case, how it was made unconstitutional. We also discussed that. After that we saw that how the judges are removed. We discussed that too in a very detailed way, how the resolution is passed both in the Rajya Sabha and the Lok Sabha by the special majority 2 favor, and then the president gives the final order. After that we discussed about the seat of the Supreme Court. What we discussed the seat of the Supreme Court, while Supreme Court will be. Then we discussed what is the how there is the demand for the regional bench. We discussed that, and we saw what are the pros related to regional bench, what are the cons related to regional bench, and we also discussed what Supreme Court said about the regional bench, what how it is going, how Supreme Court is a national institute, and if it is set up in the regional areas, it will dilute the national integrity of the Supreme Court, and also it may fall under the influence of the local government or regional government there. After that, we discussed the jurisdiction of the Supreme Court. We saw how it has the original jurisdiction related to certain cases, for example, fundamental rights. Then we saw that how it has an exclusive jurisdiction related to certain certain facts. For example, if there is a treaty, pre-constitutional treaty is there. If there is a interwater dispute, how it has the exclusive jurisdiction related to that. Then we also saw that after this in the exclusive jurisdiction, it is in the pre-constitution and the interwater dispute, it is not exclusive to it, it is exception that the Supreme Court is not directly involved with these cases. But in the exclusive jurisdiction, we saw that if there is dispute between center and the state, if there is federal issue, how Supreme Court comes in the picture. After that, we saw that how it has a writ jurisdiction, which we had already discussed in the fundamental rights. After that, we saw that how it has the appellate jurisdiction. How the Supreme Court's decision judgment is binding on all the courts except on the Supreme Court. How Supreme Court can review, in the appellate jurisdiction, how the cases from the lower courts, for example, from the high courts, can come into the Supreme Court, and how Supreme Court can review those cases and can revisit those cases. How Supreme Court has the appellate jurisdiction. It may be related to the civil cases, it may be related to the criminal cases, it may be related to the constitutional cases. And how they are admitted in the Supreme Court, you need the certificate of the High Court. But in cases of the criminal cases, when the punishment is death sentence or the life imprisonment, then you don't need the certificate of the High Court. After the appellate jurisdiction, we saw that it has, then we saw that suppose if the Supreme Court will not give this, if the High Court will not give the certificate, then there is something called special leave petition. It is up to the discretion of the judge whether he will accept it or not. You cannot claim it as a right. After that, we saw that how the Supreme Court has the advisory jurisdiction under Article 143, and in this we saw that if the matter is pre-constitutional, then it is binding on the Supreme Court to give the advice. But if it is a constitutional matter, then Supreme Court may stay away from the advice. They may not give this advice. On paper, this advice is not binding on the president, but in reality, it is binding on the president. If a question is asked, this advice under Article 143 is binding on the president, you have to say it is a wrong statement. Then after that, we saw that how the Supreme Court has the revisory jurisdiction, how it can review the petition, how its ruling is binding throughout the country, but not on the Supreme Court itself. It can review its decision, but this revision can be done for that we have the review petition. It can be done within 30 days of the original judgment, and it would be heard by the same judges as much as possible, and and the strength will remain the same. After, if the review petition is rejected, then you can go for the curative petition, and this curative petition within a reasonable time span, it can be accepted, it can be submitted there. And what is the strength of this? Who are the judges who are going to look after it? It is the same bench plus 3 extra judges. For example, in the Superior versus Union of India, the case related to homosexuality, so it would be the same bench, 5 judge bench plus the 3 extra. Then there would be voting by the majority decision, then the case could be studied again. So this is what so far we had discussed. Now in today's discussion, we are going to discuss the judicial review. We are going to discuss judicial review, and we will see what is the scope of judicial review, how it was not originally part of the constitution, but it was adopted by the judiciary. We will try to discuss that, and we will see where we will reach today. Let me rub it first, and I will write the topics which we are going to conduct today, which most probably we will try to conduct today. So first we are going to discuss the judicial review. In judicial review, we will discuss judicial review. After that, we will see, you know, how what does the Constitution say about it? What does the Constitution say about? Let's discuss it. Let's leave what topics we are going to discuss today. Let's see where we will reach. Judicial review. If the basic by definition we go by the words we go the judiciary. What does the judiciary do? We in our first class we discussed there is separation of powers. There is separation of powers. What is the separation of powers? The executive organ, the legislative organ, and the judiciary, they will check and balance the two. How the judiciary will check and balance the executive? Executive will frame the rules, execute the rules. Legislative, they will form the laws, and the judiciary will see. Judiciary will see whether these laws and rules are in line with the Constitution or not. So in this way, judiciary is going to review it. Judiciary is going to review the laws formed by the legislature and the laws executed by the executive. It would be it would be checked by the judiciary. It will see it whether it is in line with the Constitution or not. If it is in line with the Constitution, then it stays there. If it is violative of the Constitution, then it becomes void. So with respect to the Constitution, the term itself, the judicial review itself, it is nowhere mentioned in the Constitution. It is, please remember that a statement about it may be asked in the prelims exam. Is judicial review written anywhere in the Constitution? No, it is nowhere written in the Constitution. But we trace judicial review from various acts. For example, when we discussed the fundamental rights, we saw that there is something called Article 13. Under Article 13, we saw that if, for example, the legislature, they will try to form a new law and they will try to amend the Constitution. Suppose they will try to amend the Constitution. They will try to amend the fundamental rights or restrict the fundamental rights or delete the fundamental rights. Such a law or ordinance or whatever it would be or custom, it would be deemed as unconstitutional. It will become void. Such law will become void. So how will it be achieved? Who will declare this law is void? This would be declared definitely by the judiciary. This would be declared by the judiciary. So the judicial review, the first scope of the judicial review, if we can trace it, it is traced in the Article 13 of the Indian Constitution. Then we have Article 32, which gives waive for the writ jurisdiction, where if your fundamental right is restricted, you can go to the Supreme Court directly and ask for your rights, why they are restricted, and to restore them. And similarly, with respect to high courts, under Article 226, you can go to the High Court. So these are the constitutional acts, articles which deal with the judicial review, from where we can trace the judicial review. So with respect to, as we saw that any law which is passed by the legislative and any rule which is passed by the executive will be reviewed by the courts. So judicial review, if we will define it, it is any law passed by the executive. Once the law is passed, then the rules are framed by the executive. Rules are framed by the executive. Any law passed by the legislature, rules framed by the executive, it will be it will be reviewed. They will be reviewed by courts. They will be reviewed by the courts. This is called judicial review. So with respect to judicial review, there are some important points which you need to know. For example, a question may come to your mind, sir, tomorrow you may think of that. Tomorrow the legislature, they are going to make a law with respect to the death tax. Hypothetically, you are thinking that what would be this death tax look like? That they are going to tax the inheritance, what you get from the inheritance. Of this inheritance, 50% you will have to give to the government. So you are assuming that. Then can you go to the court? You are going to the court. You have an assumption, you have a hypothesis. You go to the court and you want court to restrict it, restrict it before they are going to enact it. You know what court will say to you? Court will say, get out from here. What the hell are you talking? Let them frame the law, then we will decide. So with respect to this, the courts, they don't answer the hypothetical questions. The courts don't answer hypothetical questions. But in case in case the president asks their advice, there they will give the they can give the advice with respect to the hypothetical questions. But in normal circumstances, with respect to normal questions, judiciary, they never, Supreme Court never answers the hypothetical questions, or judiciary never answers the hypothetical questions. Now, with respect to judicial review, if we look at the judicial review, there are two important things. When we saw in the definition itself, let me rub it first, then we will establish its base. Let me rub it. In case of judicial review, we saw there are two things. One is law made by legislature, sorry, and the second thing is rules made by executive. So with respect to the law made by the legislature, when the laws are made by the legislature, when such case goes to the Supreme Court for the review, what Supreme Court will think. For example, usually I will tell you one concept. Suppose there is anybody who is convicted. Suppose there is a person who has an allegation that he has committed a murder or any other crime. So what will be the court's approach? Until he is proven guilty, he will be assumed that he is innocent, and the bail would be given to him. And the burden of proof is not on the accused but on the petitioner, who is on the person who has taken him to the jail. The burden of proof is on the police to prove that he has committed the crime, rather than on the person who is accused. But with respect to money laundering cases, or we have the cases related to terror financing, in those cases, in such cases, the burden of proof is on the accused, not the petitioner, not the person, not the police. It is on the accused that they have to prove that they are innocent. Similarly, with respect to judicial review, when there is law formed by the legislature, here what judiciary will assume with respect to the laws formed by the legislature, the judiciary will assume that there is a presumption of constitutionality. In the legislative wing, there is the presumption of constitutionality. For example, if any law is made by legislature and it is this thing when goes to the Supreme Court, and the Supreme Court will presume that this law is made by the legislature, then it would be in line with the constitution, because they are elected people, they know how to form the laws. But once the rules are framed, it is framed by the executive, it may be framed by the bureaucrats. Here what Supreme Court will say, that the presumption of constitutionality will not work in this regard. In the regard of the rules, in things with respect to executive, the presumption of constitutionality will not be followed here, and the Supreme Court may bring forward, may stay the law, may stay that, may put some staying action on that. For example, we have fact check unit, which has been stayed, which was brought up by the executive, and judiciary is staying it. So with respect to the laws formed by the legislature, there is a presumption of constitutionality. With respect to the laws made by the legislature, there is presumption that it may not have followed the constitutionality. So this you have to understand. So with respect to judicial review, we understood one thing, that it will check it will review the laws framed by the legislature and the rules formed by the executive. So in this regard, the judiciary acts in a very different way. Sometimes judiciary will restrain, and sometimes judiciary will be very much proactive, and it would be called as activism. So let's discuss now what is the judicial restraint and what is judicial activism. Now let's try to find out what is this, and we will try to understand it through the examples, how judiciary restrains and how judiciary is proactive. About the judicial restraint, for example, whenever when we got the independence and we enacted the constitution, at that time we discussed the evolution of federalism in India in 1950s to 1967. 1952 to 1967, we have the first phase of federalism, and we have the strong center with the strong state. So it was a one political party rule. So at that time, when there is a brute majority enjoyed by the political party, what happens? The judiciary will try to restrain. At that time, the judiciary will try to restrain. For example, we have the electoral, uh, we have the case with respect to the electoral. For example, we have the case with the electoral bonds. It was very much understood that it is violating the constitution, but when the case went to the Supreme Court would had easily stayed this, but they did not stay it till 2024, and finally by the verdict it was made unconstitutional. So what happens in the judicial restraint? The Supreme Court, the courts will restrain. They will not execute. They will not execute their power. They will just listen it. For example, similarly with respect to Article 370, the Supreme Court restrained it, and when the question was asked whether, and eventually the decision was given, but still when the question was asked, can a state be changed to the union territory, can a state be degraded to the union territory, isn't it the violation of the federal structure, isn't it the violation of the federal India as a federation? So to this, the Supreme Court has remained silent and said if such case would ever emerge again, then we will answer this. So when the Supreme Court sees, when they want to restrain, they will restrain, and it is usually seen when there is the brute majority enjoyed by the political party in the rule. So with this, as it is the judicial restraint, at the same time there is judicial activism. So what is this judicial activism? This is in a nutshell what you had understood it, judicial restraint. Now what is this judicial activism? Judicial activism. In the judicial activism, judges are very eager to give their judgments. For example, we have various cases, with respect to, we have the 2G scam, where it was not, where the Supreme Court was very much, where the judges were very much eager to come into the picture and give the judgment with respect that you cannot go for the, with respect that you cannot go for the first come first service. You have to go for the auctions. Similarly, judicial activism. To understand the evolution of judicial activism, first we have to understand how it is being misused, or how judicial activism was was the most efficient thing which we had achieved in the judiciary, was the most important thing which we had achieved in the judiciary, but at the same time it has been most misused. So with respect to this, to understand the judicial activism, let's try to understand first the public interest litigation. So let's see how it evolved. It was the year 1979 when there was a lawyer who was born in Kenya, and she was Indian origin. Her name is Kapila Hingoroy. Kapila Hingoroy. She was a lawyer. I'm sorry if I am not pronouncing her name properly because of the language difference. So her name is Kapila. Let's keep it to it. And she was reading the newspaper, and she saw one fascinating thing in the newspaper, which was very much disturbing. That in the Bihar there are so many convicted people. There are so many people who are under trials, and these under trials, there is nobody to take their cases. And for example, if they had committed any crime and its punishment was 5 years, they are under trials in the jails for more than 7 years there, and they are still under trials. There is no final judgment has not been given over them. So this is huge injustice towards these under trials. So what she did, she went to the court, and what she did first, she went for the public interest litigation. She went for the public interest litigation, and the courts did accept it without any query, and the courts did not question them what is your locus standi. So with respect to the public interest litigation, there is least locus standi. It is for the public, it is for the public good. The measure is that the justice should be as democratic as it could be, the judiciary should be as democratic as it could be. It should be available to every hook and crook of the nation. It should be available to everyone. So there is least scope of the locus standi how you are related to this case, and this case was given to her that you can take up this case, this public litigation case, public interest litigation case. And the name of this case, it was named after the Husanara Khatun, who was also a Husanara Khatun, who was also the under trial at that time. She took up this case, and it gave the way for the judicial, it gave the way for the public interest litigation. Its aim was, to reach every corner of the country, to reach the marginalized, to give the justice to the poor, to give the justice to the marginalized people. Similarly, then it became the trend. Then we have the lawyers like Bhushan, lawyers like Prashant Bhushan. Sorry, he's one of the famous name with respect to the public interest litigation. Because of this public interest litigations, many fundamental rights were given to us. For example, the fundamental right with respect to the clean environment, it is because of the public interest litigation. And with respect to the protection to the endangered species, how it has been established as the fundamental right against adversely effect of climate change is a fundamental right under Article 21 and 14. So this, because of this public interest litigation, it gave scope to what? It gave scope to judicial activism. Because of this, the judiciary started to reach to the places where it was not earlier reaching. So judiciary, it widened its scope. It became more active even when cases came to it where the executive, where the legislature, they were not making laws with respect to the for example, the executive and legislature. What they were doing, they were not making laws with respect to the environment protection, or they were not making laws with respect to the protection of these birds, for example, great Indian bustard. So there the Supreme Court came in, they gave the guidelines what should be followed. Such guidelines should be followed. Similarly, with respect to ragging was there, the Supreme Court came in and gave the guidelines. Similarly, with respect to Vishaka guidelines, the woman at workplace, the sexual harassment they go through, there the Supreme Court came in and gave the guidelines. So with respect to this, because of this because of the public interest litigation, it increased the scope of the judicial activism. But here you have to understand this first one issue with the public interest litigation is that it is a two-sided sword. It is a twin-edged sword. Sorry, it is a twin-edged sword. And here, even though it had the great intention when it started, but over the time it has been misused. It has been misused by the lawyers for their public interest, for their publicity. It has been misused by the people for their personal interests. For example, we have the case in Srinagar where a person approached the Supreme Court and said, High Court of the Srinagar, Jammu and Kashmir, and said there that, sir, there is a flyover is in construction near a school, and it is going to impact the school there. But when the courts appointed the amicus curiae, when the courts appointed amicus curiae, what is this amicus curiae? They will give advice to the courts what to do with respect to this matter. When the courts appointed the amicus curiae, the amicus curiae said that this person is lying. Actually, he has his property near that school, near the flyover, and his property may come under strain because of this flyover. So then the High Court said that they punished this person by the 20,000 fine, and they told him that you cannot file such petition again or you will go to the jail. So with respect to this, there are various personal interests. People are trying to mix the personal interests. Similarly, if we take the example in the Gujarat, there are two persons approached the Gujarat High Court and told the High Court, sir, there is industries are going on there, and we have the automobile industries, especially in the tire industry, we use asbestos as a substance, but this asbestos as a substance is very harmful for the health of the people. Please put ban on the asbestos. But same thing was followed by the courts here. They appointed the amicus curiae, and the amicus curiae said that this person has the alternative for the asbestos substance, asbestos substance. Now he is trying to restrict the formation of manufacturing of asbestos, so that he can replace this substance by their own substance. So in this way, this case was also nullified. So what is the question here? The point here that even though the main aim of the public interest litigation was to reach the hook and crook of the people, to reach to the poor people, to reach to the marginalized people, so that they can get access to the courts, to reach those poor people who are in the jails, who had no money to be represented, who has no family to who will represent for him, so that they will get the justice as quickly as possible. But it has been misused, by many people. It has been misused for the public personal interests. It has been misused for the publicity, and it is wasting the time of the courts. It is increasing the burden on the courts, and at the same time there were many interesting public interest litigations files. For example, a PIL was filed against the Yo-Yo Honey Singh's song, as this song is very much vulgar. For example, another PIL was filed against the Jism 2, that it should be banned because there is a ex-porn star who is the actress in it. Then various other PILs were filed. Similarly, a PIL was filed over the Dhanush's song, the Why This Kolavaridi. So various other such PILs were filed, which are least important. Nobody gives a damn about those issues, but still for the personal interests, for the personal publicity, they were filed. So that right now we are even studying them. So this how much publicity they had got from this. So when these issues came into the court, when courts started to realize the issues of the PILs, how they are wasting the time of the courts, how there is increase of the burden. Similarly, then the courts came up with the guidelines. These guidelines strike the balance between between the PIL and its restriction. So what were the guidelines? The court should verify the credentials of the petitioner. The first guideline: if a person is going for the PIL, then the court should verify the credentials of that person. What are his credentials? Why he is why he is filing this PIL? What is the reason for that? And the second, only PIL should only be filed when there is the violation of fundamental rights to any community. Then only the PIL should be filed, or there is the violation of the justice, then the PIL should be filed. So this is the PIL. Because of this PIL, it gives scope to the judicial activism, and this judicial activism, when it goes out of hand, when the earlier it was the need of the courts, judicial activism was sometimes need of the courts. It was the need of the courts to render the justice, to render the justice to the people. When the executive was sleeping, when the legislature was sleeping, at that time there was a need of the judiciary to come in and frame some laws and give us some rules so that we can follow them. But once this was the necessity, when this necessity has become the it has become the duty of the courts. Now it is becoming, now this necessity is becoming the habit of the courts, and it is turning out to be the judicial overreach. So there is a very thin line between the judicial activism and judicial overreach. So with this, what is this judicial overreach? You cannot differentiate judicial activism from the judicial overreach. For example, same case of the 2G scam, the case with respect to 2G licenses, there was no need for the Supreme Court to come in. Similarly, with respect to the for example, there are drunk drivers who are driving on the highways, truck drivers who are drunk, they are driving on the highways. One filed an PIL in the Supreme Court that there are accidents because of this. So Supreme Court, they gave an order that within 500 meters of the highway there should be no alcohol selling shop, in simpler terms. So what if there were any shops? What it did, it in a way invaded, in a way attacked their business, and they had to shift their shops. So it attacked, even though the decision was good, but it attacked their business. It shifted the shops. Second, it would impact their ranking. It would impact their star ranking of those hotels. And at the same time, was it necessary? Why not Supreme Court directed these police to act more proactively, to have a better checks and balances, to follow the rule, the guidelines, to follow the road guidelines more religiously? That would have been better solution than shifting the shops. So this is also one of the cases where we see there has been the overreach. Similarly, if there were the need of the Vishaka guidelines, when it was important, it was important that there should be the rules with respect to the workplace, but the legislative was absent there, executive was absent there. Then the Supreme Court came in, they gave their rules, and those rules, the Vishaka guidelines, they became the basis for the Posh Act in 2013. So there are ways, this is so much interesting, this judicial activism and judicial overreach. It is so much so much close to each other. It is very hard for a person to identify them, but the simplest way is when it is necessity, where it is necessity, it becomes the judicial review activism, and when it becomes the habit, it becomes the judicial overreach. Similarly, we have the case, for example, judicial overreach and activism. We have the case of Husanara Khatun versus the state of Bihar, where the under trials, where 40,000 under trials were released in this case. So in this we can say it was the judicial over activism. We have the Sumit Batra, he wrote letter to the justice, then judge. He accepted it as an PIL, and there was there were these inmates were not treated well with respect to that. So after this laws were formed, then various other laws, for example, exploitation of worksmen at the construction sites, then it was a pilot under the PIL, and the judiciary came there, gave their guidelines with respect to that. Similarly, various other with respect to the liquor on the highways, we discussed that. And also it in a way gave way, this judicial, these PILs gave way for the judicial job. It gave way for the judicial legislation. It gave the way for the judicial legislation. So this judicial activism, this PIL, it gave the way for the judicial legislation, where the legislatures should have been involved. There the judiciary came in and they started to make the laws. And the most in a way misused laws, acts under Indian article or article 141, under which the Supreme Court, whichever judgment they gave, it is binding on full country, and this becomes a law of the land. Similarly, we have under article 142, where the Supreme Court can give any judgment to render the full justice. So in these laws also they gave way for the judicial legislation. Similarly, in the Vishaka case, Vishaka guidelines were given in 1997, and which became the basis for the Posh Act of 2013. Then anti-ragging guidelines were given. Then also we discussed the case related to the Srinagar flyover. So these are various cases where judicial activism, it gave place for the judicial overreach. So there is a very fine line. You cannot differentiate the two. It can be judicial activism for the Supreme Court, for the courts. Same can be the judicial overreach for the executive. So there is no clear definition, no clear line between the two. Now there is another concept with respect to the judicial review. We are discussing judicial review. In it we had discussed the judicial restraint, we discussed judicial activism. Now similarly, there is another concept that is called judicial evasion. What is this judicial evasion? It is very much similar to judicial restraint, where the courts, where the judges will remain silent. They will not act proactively. They will let the things go as they are going. So similar, there is judicial evasion. For this, to understand the judicial evasion, we can understand it through the electoral bond case. Electoral bond case, which was against which in 2018 it was brought in. The PIL was filed, petition was filed against it, but it was very much understood by everyone that it is unconstitutional, but the Supreme Court did not state it. It let it continue, and eventually in 2024 the Supreme Court said that it is unconstitutional. So the decision of the Supreme Court, it could have given the decision in 2018 itself and state the electoral bonds, but Supreme Court did not went for that. So this is an example of the this is the example of the judicial evasion. Similarly, with respect to the Citizenship Amendment Act, with respect to the guidelines, what were the guidelines, the Supreme Court had stayed silent. They had not stated. Similarly, with respect to Article 370, which we had already discussed. So this is called the judicial evasion, where the Supreme Court will try to remain silent. After that, now we had discussed the judicial review also. There is again another concept with respect to the judiciary. That is, there are so many cases pending in the judiciary. Why there are so many cases pending? There are many cases pending in the high courts. Approximately 1 lakh cases, near to 1 lakh cases pending in the Supreme Court, and 87% cases which are pending in the out of 33 crore cases. 87% cases are pending in the district court. So what is the reason for that? So we have to understand the judicial judicial backlog. So as we saw that there are less than 1 lakh, nearly 1 lakh cases pending in Supreme Court, and 83% cases pending in the district courts, and the rest is pending in the high courts. So what is the reason for that? First of all, who are better to answer this, the reason for that? If we look at the working of the judges, how they work. For the Supreme Court, it will remain, Supreme Court judges, they will work for 193 days. The High Court judges, they will work for 210 days, and the District Court judges, they will work for the 245 days. As compared to how we work, they have very minimal time of the work on which they work. But this is not the real picture. Even though they work lesser than us, their stream is different. But still, when they are taking the vacations, in the vacation time, they are not just staying idle. What they are doing, they are writing the judgments. They are studying the cases from the international courts, so that they will know what to implement in and what to not implement. So they are not even staying idle, but they are also learning at that time. So this is, we can assume that this is one of the reasons, because there is less amount of, there are many days which are not, which are not occupied by the Supreme Court, where there are vacations. But still, there are backlogs. And also, even though there are vacations, even though the seats are vacant, but these seats are filled by the vacation bench, so they don't remain idle. So what are the real reasons? Then what are the real, if it is not the reason, if the vacation is taken by the judges, it is not the reason for the backlogs, then what is the reason? The reason is very much clear. The first one, look at our laws. There is problem with our laws. There we have huge number of problem with laws. We have huge number of laws, and these laws are so big. They can take up money. They are on the 100. They would be on, single law would be on 100 pages, and there would be a lot of loopholes. When there are so many loopholes, definitely, if there would be case against when two parties would be involved in a case, they can misuse these loopholes, and because of this, there is huge burden on the courts. So this is also one of the reason. Then look at our legal proceedings are very much complicated. The courts would be adjourned, the judge will adjourn the case. Sometimes judge would not be there, sometimes advocate, he will have to take many cases and he will ask for the adjournment. So definitely the legal proceedings are very much complicated in our country. Approximately 40 million cases are pending across the country. Now, even if these are the problems, what can be the solution to it? How we can reduce this judicial backlog? What can be the solution for that? So for that, we had already the solutions framed, but we are not implementing it. So what are those solutions? Look at the Malimat committee. What does Malimat committee say? Malimat committee says number of judges should be increased. First it says number of judges should be increased. Ideally it should have been the 50 judges per million, but in India we have 10 judges per million, and under these 10 judges there are huge vacancies. So what does the Malimat committee say? It says that the number of judges should be increased. Second, there are certain cases which are very much important and which have the huge importance. For example, cases related to children, cases related to women. For such cases, why not we go for the fast track courts, set up the fast track courts so that they can take up these cases. Or if it is not possible, even though you are setting up the fast track cases, still there are many cases, then those retired judges, we can call the retired judges to come in and and take up the remaining cases. Or why not go for the alternative dispute resolution? Go for the alternate dispute resolution. What is this alternate dispute resolution? Before going to the court, go for the alternate dispute resolution. Decide mutually who will listen your case. Decide the person and decide mutually that that person's decision would be final on you before entering the court. Go for the alternative dispute resolutions. Similarly, with respect to alternate dispute resolutions, we have the Lok Adalats. Lok Adalats are there, which provides the legal service under the Lok Adalats. Who are the members? It would be the retired judge, it would be the advocate, and it would be the some social servant, social activist. So these members in the Lok Adalat, they will take up the civil cases only. Lok Adalats related to Lok Adalats, they will take up the civil cases only, and also a criminal case, but where if there is any check bounce case, then they can take up this criminal case as well. So you can go to the Lok Adalats, go without the lawyer, and what decision they will give, and that decision would be binding on both of the two parties. Then also promote these Lok Adalats. Use we can use the good officers who will take the for example, there is any official dispute there in any village, so there you can consult the officers. They will solve it for them. Before, the point of it is, before entering into the courts, go for the alternative dispute resolution. Before try mutually to solve the issue, then enter into the court if you are not able to solve it. Similarly, in the COVID-19 times, we saw that we can also take the service of courts using the electronic media. We can also use the electronic media. We can do this online. Then this is also one of the way by which we can reduce the burden, and also let the retired judges to clear the backlog. What is the current age of the Supreme Court judges? It is 65 years, and retirement age 62 for the High Court. And it is, if you look at the retired judges, for example, you will look at the Justice Chandrachud. He seems very much young still, but he has been forced to retire because he had passed the age of 65. So why not we increase it to 75? They are still capable of making the decisions. So why not we increase this age limit? Also take the best procedures, practices which are most common in other countries. For example, public access to electronic records, public access to court electronic records, also multi-door court houses like in Singapore, and similarly the alternate dispute resolutions as in Australia. So there are these ways. By these ways we can try to reduce this backlog. And what is the other major issue of the backlog? When there are backlogs, when cases are not solved in time, we, in the preamble of our constitution, it is said that we should give the justice, whether political, economical, or social. The justice is highlighted, that justice should be given. And if justice is delayed, then it means that justice is denied. For example, there is an undertaker who is convicted, who has been alleged that, who is accused that he has committed any crime, and he will remain in the jail. He will remain in the prison for the longer time, for 14 years or 20 years, and after 20 years the Supreme Court will say that you were not guilty, what will happen to this person? Where from he will get these 20 years back? Where from he will get that reputation back? So the justice, giving justice on the time, it is one of the uh, primary requirement of giving justice to anyone. It is not you will give justice would be denied, then the justice would be given. If you have to give the justice, it should be given in the speedy time. There should be the speedy justice. It should be given, justice should be given in a very small time period. Then only we can say that justice has been given. Because of this judicial backlog, it denies the justice, even though justice would be given later, but it is equal to denying the justice. So with this, we had completed our topic with respect to the Supreme Court, the important concepts which were important for us to understand. From yesterday we are discussing it. Now here we will put some discussion on the High Court too. With respect to the High Court, we know that there are 25 High Courts in our country, in 28 states and 8 UTs. What the Constitution says that for every state there should be every state should have an High Court. This means that 2 or 3 states, they should also have an High Court, but they can have the common High Court. So with respect to the composition, what does the composition say about the High Court? It says that there should be the Chief Justice of the High Court plus such other judges as may be appointed by the President, With respect to the Supreme Court, it is the appointment, it is decided by the Parliament, but here it is appointed by the President as Chief Justice of High Court, and such other judges as may appointed by the President. And also with respect to High Court, we had discussed how judges are appointed, how they are qualified, how they are appointed, and how they are removed. We had discussed that already. So now the question comes, which can be relevant for your mains preparation, whether the High Courts, they are whether the High Courts are relevant. Second, whether the jurisdiction of High Court has been subjected to relentless attacks. Has it been subjected under the relentless attacks? That we have to understand. How Supreme Court in a way hijacks the provisions, hijacks the powers of the High Court, how Supreme Court restricts the powers of the High Court, and similarly how the Parliament restricts the powers of the High Court. So let us discuss that. How Supreme Court can restrict it. Supreme Court can restrict it through the transfer of cases. They will transfer the cases to themselves, and in this way they will restrict the if suppose the High Court was deciding on the case, what Supreme Court will come in, it will ask the High Court to transfer the case to the High Court. And how Parliament can restrict it? Parliament can restrict it by the creation of tribunals. So Parliament can restrict it by the creation of tribunals. For example, instead of going to the High Court, you will go to the tribunal, and what would had been the how case would had reach to the Supreme Court earlier. It would go from the district court, it will reach to the High Court, and from there it will reach to the Supreme Court. Now how the Parliament can exclude the role of the High Court here? Here they will set up the tribunal, and from tribunal the case will directly reach to the Supreme Court, and it in a way restricts, or it in a way attacks the High Court's High Court's provisions. So in this way the Supreme Court, the Parliament can attack the High Court's provisions. So here we came up with the new term called the tribunal. What is this tribunal? It is an quasi judicial body which has both the judicial it has both the judicial as well as administrative function. It has the members would be from the judiciary as well as from the administrative domain. It will have the members from the judicial as well as the administrative domain. So what does the Constitution say about the tribunals? Initially Constitution did not say anything, but it was the Sovereign Singh Committee in 1976. It was the Sovereign Singh Committee which actually recommended that there should be the there should be the tribunals, and by the 42nd Constitutional Amendment Act, the tribunals were created. 2 articles were inserted, which is Article 323A, which is related to the administrative tribunals. It is the Parliament who can make the administrative tribunals, and Article 323B, it is related to the other tribunals, tribunals of other matters. And these tribunals of other matters, who can create them? It is Parliament as well as the state legislature. They can create the tribunals of the other matters. With respect to administrative tribunals, it is only the parliament who can create it. So they are created, they will listen the cases and they will hear the cases, and their aim is to reduce the burden of the cases on the Supreme Court. But here, as we know that it would be created by the departments itself. So definitely there are chances that there would be the clash of interests in this. So definitely there is a need to check and balance it. For this, for the appointment of this committee, as we saw that there would be the members from the judiciary as well as the administrative part. So for this, to keep the checks and balances, there was search cum selection committee was created for this. Under this search cum selection committee, through the Tribunal Reform Act was passed actually. Tribunal Reform Act of 2022, it was passed, and under this search cum selection committee was created, who will select the members for these tribunals. Who are the members? First, it would be the Chief Justice of India, or a Supreme Court judge nominated by him as chairman, or Supreme Court judge nominated by him as the chairman. Second, who would be this member? Second, it would be it will consist of two secretaries nominated by the central government, two secretaries nominated by the central government. Three, the sitting or outgoing chairperson or retired Supreme Court judge or a retired Chief Justice of High Court, he will be the member of it. Then the fourth, it would be the secretary of the ministry under which the tribunal is constituted. The secretary of the ministry under which the tribunal is constituted. These members, they will select the members for each tribunal, and they will decide what the cases there. The function of this was to reduce the burden on the Supreme Court, to further reduce the burden of the Supreme Court. But unfortunately, because through many tribunals were also created, but at the same time, through the money bill, many tribunals were also removed. Like we have the Film Certification Appellate Tribunal, FC80, it was removed by the use of Article 110 as the money bill. So the aim of the tribunal was to reduce the burden, but unfortunately it has even contributed. Now the cases are so much in the tribunals that the burden of cases in the tribunals had increased. Secondly, there are many unnecessary actions taken by the state governments or the parliament, where they use the money bill, in which they end any tribunal, they cancel any tribunal. So this is with respect to the tribunal's aim. What was the aim? What we were discussing, how it is reducing the impact of the high courts. Similarly, after that, the another question can be asked: can High Court review the law passed by the Parliament? The answer to it is 100% yes. High Court can review the law passed by the Parliament. After the High Court, we have another court which we have to discuss, that is the District Court, which would be the last point of our discussion with respect to judiciary. After that, we will conclude our discussion. After the High Court, we have the District Courts, who is going to appoint the District Court judges, that we will see. We have District Courts. So District Courts, or we can say them session courts as well. They would be district courts in the civil cases, it would be called the district court, and session court in the criminal cases. In the criminal cases, it would be called as the session court. Who will appoint the district court judge? He will be appointed by the governor. The governor will appoint him through what? Through the examination would be there by the Public State Service Commission. They will conduct the exam for the district judges. Or second, after the consultation with the Chief Justice of the High Court. After the consultation with the Chief Justice of the High Court, once they complete the 10 years as a district judges, they can be promoted to be the judge of the High Court. There are various the most burden of the cases is in the district courts. Approximately 87% of the case burden is in the district courts, and the reason is because there are huge number of vacancies. So to overcome this huge number of vacancies, there is demand that all India Judicial Service should be created. India Judicial Service should be created, and it should come under the UPSC. They will appoint them. Once UPSC will appoint them, they will know how many how many vacancies are there. They will appoint them in this regard itself. But there is an issue. That issue is of the language. The language used at the High Court and the Supreme Court is English or Hindi, but at the lower courts it is the regional language. So because of the issue of the language, you need to have the proper strong hold over the language. So because of that, you cannot go for the you cannot go for the national all India judicial service, because you cannot everybody, a person from the Tamil Nadu cannot speak Kashmiri in Jammu and Kashmir. So this is the case, because for a judge you need to have the proper understanding of the language in which you are going to listen to those people. So that is the reason which is why it has not been created, even though 42nd Constitutional Amendment Act 1976 had created all India judicial services, but it has not been notified yet. So this is about this is in nutshell about the district courts, which can be relevant for your prelims exam, how they are appointed and who appoints them. After that, we have the Gram Nayal Layas. It was created in 2009. Purpose was that every village should get originally meant to be, they were originally meant to be mobile courts, so that we can reach to the every village. It was supposed that we will set up 16,000 Gram Nayalas, but unfortunately we had only set up 450 of them, GNs, 450 GNs, and we had not rendered the justice what the people of the villagers had dreamed of. And there are, often they are absent or they are not available here. So it will, the aim of this was to reduce the burden, but it is still fueling the burden of the cases in the high courts or the Supreme Courts. So with this, the judiciary is over. From yesterday we are discussing it. If there is any confusion, please do write in the comments. We will try our best to clear that confusion, and subscribe the channel. Thank you for staying with me. Thank you very much.